You are listening to HOA Spot. The easement word came out like a curse. Betty pointed at a single board cut and yelled that the cut angle was not approved. You can be mad or you can be compliant, she said, standing on the curb with her arms crossed and a rolling file cart parked behind her on the sidewalk. I looked at the sample board leaning against my truck bed. It was a 6-inch cedar plank with a 45-degree miter on one end. I had cut it that morning to show the fence contractor what I wanted. Betty had appeared out of nowhere while I was measuring the property line with a tape measure and a can of orange spray paint. This is a sample, I said. I have not even started building. She shook her head. The enclave at Stonegate Property Owners Association requires pre-approval for all exterior modifications. That includes samples. That includes test cuts. That includes anything visible from the street or adjacent lots. I live in Pittsburgh, Pennsylvania, in a neighborhood where the compliance chair carries a ruler and a stopwatch. Betty Davis is the social committee chair who spreads rumors, but she acts like she runs the architectural review committee too. She had shown up at my house 3 times in the past 2 weeks, each visit more aggressive than the last. I work as a municipal code researcher who reads ordinances for fun, so I knew the city allowed privacy fences up to 6 feet without a permit as long as they met setback requirements. I also knew the HOA covenant said nothing about sample boards or test cuts. I had read the entire rule book twice. Betty pulled a clipboard from her rolling file cart. The cart was a wheeled contraption with 3 tiers of file folders, binders, and labeled dividers. She used it for enforcement paperwork. I had seen it at neighborhood meetings. It was her signature prop, and she was never without it. She flipped through pages on the clipboard and tapped one with her finger. No readable text was visible, but she acted like she was citing chapter and verse. This is a violation notice, she said. You have 72 hours to remove the sample board and submit a formal application for fence approval. If you do not comply, the fine is $100 per day. I do not negotiate with violations, she added, using her catchphrase for the first time that day. I took a breath. My escrow closing date was 5 days away. Any lien threat could blow up the sale. I was buying this house, not selling, but the HOA had the power to delay closing if they filed a lien or a stop work order. My real estate attorney had warned me about it during the contract review. I need to install this fence before I close, I said. The survey shows the property line. The city code allows it. The HOA covenants do not prohibit it. Betty smiled. Go ahead and call whoever you want. I have a committee for that. That was her boomerang line, and she delivered it with the confidence of someone who had never been challenged. I did not argue. I just nodded and walked back to my truck. I had a plan, but it was not a speech. It was a document. I spent that evening reading the HOA insurance policy. I had requested a copy from the management company 2 weeks earlier as part of my due diligence. It was a thick document, and most of it was standard liability coverage. But buried in the fine print was a clause about harassment claims. If the HOA faced multiple complaints alleging selective enforcement or targeted harassment, the insurance carrier could reduce coverage or refuse to renew the policy. I had already started gathering evidence. I had meeting minutes from the past 6 months showing that other homeowners had installed fences without submitting formal applications. I had quorum logs proving that several enforcement votes had never legally happened because the board failed to meet the minimum attendance requirement. I had photos of identical fences in the neighborhood that had never been cited. But the trump card was the insurance document. If I could show the HOA attorney that Betty's behavior was creating a legal risk, the board would have to act. I let the meeting move on because my move was not a speech, it was a document. The next morning, Betty showed up again. This time she had a vendor with her. He was a contractor I had never seen before, wearing a high-visibility vest and carrying a clipboard. Betty introduced him as a safety inspector hired by the HOA to verify compliance with setback and easement requirements. "I did not hire you," I said to the contractor. He shrugged. "The HOA did. I am just here to measure and take photos." Betty stood behind him with her rolling file cart, arms crossed, watching. "This is part of the verification process," she said. "All exterior modifications require a site visit." I knew this was escalation step 2. She had already hit me with a brand new fine that appeared out of thin air with no vote. Now she was sending vendors to my property without permission under the excuse of safety. It was harassment, and it was obvious. I pulled out my phone and started recording. "I am not consenting to this inspection," I said. "You do not have my permission to enter my property." The contractor looked uncomfortable. He glanced at Betty, then back at me. "I need authorization from the homeowner," he said. Betty's face turned red. "The HOA has the authority under the covenants," she snapped. "Read Section 12. I had read Section 12. It covered emergency repairs and common area maintenance. It said nothing about inspections or vendor access. The contractor left. Betty stayed. She stood on the curb and made a phone call. I could hear her voice rising as she talked to someone on the board. She kept glancing at me, and I kept my phone recording. A mail carrier walked past, trying to navigate around the tools and posts I had stacked near the curb. He gave us a look and kept moving. Witnesses were good. Betty hung up and walked over to me. "You are going to regret this," she said. "The board is meeting tonight, and we are going to vote on an emergency fine. $500 per day until you submit an application and remove all materials from the property." "I do not negotiate with violations," she repeated. I smiled. "That is funny, because I have been reviewing the quorum logs. Half of your enforcement votes did not have enough board members present to be legal, including the one you are planning tonight." Her face went blank for a second, then twisted into anger. "You do not know what you are talking about." I shrugged. "We will see." That night, I did not go to the board meeting. Instead, I contacted a former HOA board member who had resigned 2 years earlier. His name was Greg, and he lived 3 streets over. I had met him at a neighborhood cookout, and he had warned me about Betty. "She runs the social committee like a surveillance operation," he had said. "She keeps files on everyone." I called Greg and explained what was happening. He was not surprised. "She did the same thing to me when I tried to replace my driveway," he said. "She invented a rule about concrete color and threatened to fine me. I resigned from the board because I could not stand the drama." I asked if he would be willing to testify or provide a written statement. He said yes. He also told me something I did not know. Betty had a cozy relationship with a tow vendor, and the call logs showed it. She had used HOA funds to pay for unauthorized tows, claiming they were for parking violations, but the tow company had billed for vehicle relocations that had nothing to do with HOA business. That was the twist. Betty was not just enforcing rules, she was using HOA resources for personal vendettas. The next day, I received a certified letter. It was a formal violation notice with a $500 fine and a demand to remove all fence materials within 48 hours. The letter also threatened a lien if I did not comply. My escrow closing was now 3 days away. If the HOA filed a lien, my lender would pull out and the sale would collapse. I had already spent money on inspections, appraisals, and moving costs. I could not afford to lose the house. I called my attorney. She reviewed the letter and the quorum logs I had gathered. "This is selective enforcement," she said. You have a strong case, but it will take time. If they file a lien before closing, we will have to fight it in court, and that could take weeks. I did not have weeks. I had 3 days. That is when I decided to deploy the trump card. I made 2 copies of the HOA insurance document highlighting the harassment clause. One copy was for the HOA attorney, the other was for the board president. I also prepared a formal complaint outlining Betty's pattern of selective enforcement, vendor abuse, and the unauthorized tow payments Greg had told me about. I sent both documents via email and certified mail. The subject line was simple: legal risk notice. The board president called me within an hour. His name was Tom, and he sounded nervous. "We need to talk," he said. "Can you come to my office tomorrow morning?" I told him I would be there. Tom's office was in a strip mall near the neighborhood entrance. It was a small space with a desk, 2 chairs, and a filing cabinet. Tom was in his 50s, gray hair, business casual. He looked tired. He gestured to a chair. "Sit down," he said. I sat. He opened a folder on his desk. It was my complaint, printed and highlighted. "This is serious," he said. "If what you are saying is true, we have a big problem." "It is true," I said. "I have the quorum logs. I have photos of other fences that were never cited. I have witness statements. And I have the insurance document that shows you are at risk." Tom rubbed his face. "Betty has been on the board for 6 years. She handles most of the enforcement because no one else wants to do it. But if she has been using HOA funds for personal reasons, that is fraud." I did not say anything. I just waited. He looked at me. "What do you want?" "I want the fine dropped," I said. "I want the violation notice rescinded. I want confirmation in writing that my fence is compliant. And I want Betty removed from any enforcement role." Tom nodded slowly. "I will take this to the board. But I need you to hold off on filing anything with the state or the county until we have a chance to address it internally." I agreed, but I made it clear I was keeping my options open. If you are enjoying this chaos, hit like and subscribe for more stories where HOA rules meet hard reality. 2 days later, the fence panels were delivered. I had scheduled the delivery for early morning, hoping to get them unloaded before Betty noticed. But she was already there, standing on the curb with her rolling file cart when the truck pulled up. The driver climbed out and looked at the stack of cedar panels in the flatbed. "Where do you want these?" Betty stepped forward. "You cannot unload those," she said. "This property is under a stop work order." The driver looked at me, then at Betty. "Who are you?" "I am the compliance chair for the enclave at Stonegate Property Owners Association," she said. "This homeowner does not have approval for a fence installation." The driver shrugged. "I just deliver. I need a signature from the homeowner." Betty's face turned red. "I am telling you, you cannot unload these panels. If you do, the HOA will hold you liable for the violation." The driver looked at me again. "Do you own this property?" "Yes," I said. "Do you want the panels?" "Yes." He turned to Betty. "Then I am unloading them. If you have a legal issue, take it up with him." Betty exploded. "You do not have the authority to make that decision. I am ordering you to leave this property immediately." The driver pulled out his phone. "Lady, unless you have a court order or a deed showing you own this property, I am doing my job. If you keep interfering, I am calling the police." Betty tried to block the truck. She stood in the driveway with her arms out. The driver sighed and called the police. Within 10 minutes, a patrol car pulled up. The officer stepped out and asked what was going on. Betty immediately launched into a speech about HOA authority and violation notices and stop work orders. The driver and I waited for her to finish. The officer looked at me. "Do you own this property?" "Yes," I said, "and I have a survey and a city permit showing the fence is compliant." He looked at Betty. "Do you own this property?" "No, but I represent the Homeowners Association." The officer nodded. "Unless you have a court order, you cannot stop him from receiving a delivery. If you continue to block the driveway, I will cite you for obstruction." Betty's mouth opened, but no words came out. She stood there for a moment, then grabbed her rolling file cart and walked away. The driver unloaded the panels. I signed the delivery receipt, and the officer left. That afternoon, I installed the first post. I dug the hole, set the post, mixed the concrete, and tamped it down. A neighbor walked by and gave me a thumbs up. Another neighbor stopped and asked if I was having trouble with Betty. I told him the story. He laughed and said she had tried the same thing with his deck. By evening, I had 3 posts set. The fence line was marked with string and stakes. Everything was level. I took photos for my records. The next morning, my attorney called. "The HOA attorney contacted me," she said. "They are dropping the fine and rescinding the violation notice. They also want to settle." I asked what the settlement included. "Full approval for your fence," she said. "No restrictions, no more inspections, and they are agreeing to reimburse your legal fees." I asked about Betty. "They are removing her from the compliance committee," my attorney said, "and they are launching an internal audit of HOA expenditures." That was not enough. I wanted her off the board entirely. My attorney paused. They said they are going to address it at the next election. There is a board election challenge that flips the power dynamic. Several homeowners are running against the current board, and Betty is going to lose her seat. The board meeting that week was packed. I attended with Greg and 2 other homeowners who had been targeted by Betty. We sat in the back and waited. When the meeting reached the compliance report, Betty stood up to speak. She pulled out her rolling file cart and started listing violations. But before she could finish, another board member interrupted. "We need to table the compliance report," he said. "There is a motion on the floor to remove Betty Davis as compliance chair." The room went silent. Betty's face turned white. A vote was called. Normally, Karen tries to interrupt and the meeting votes anyway. That is exactly what happened. Betty tried to speak, tried to object, tried to cite procedure, but the board voted without her input. The motion passed 6-2. Betty was removed as meeting chair and lost the microphone control. She stood there holding her clipboard, speechless. Then she grabbed her rolling file cart and walked out. Greg leaned over and whispered, "That was faster than I expected." I nodded. I had brought a second copy of the insurance document for the HOA attorney, so the legal risk was obvious. That had been the key. Once the board understood they could lose insurance coverage, they had no choice but to act. Over the next 2 weeks, the fallout continued. The State Consumer Protection Office opened a case file based on complaints from multiple homeowners. The HOA rushed to settle, offering refunds and policy changes. Betty was forced to resign from every leadership role, including the social committee. The HOA also stopped selective enforcement after complaints piled up. They revised the compliance procedures, added transparency requirements, and hired a neutral third-party management company to handle violations. I finished the fence 2 days before closing. It was 6 feet tall, cedar planks, clean lines, exactly what I had planned. The city inspectors signed off. The HOA did not say a word. On closing day, I walked through the house one last time. Everything was in order. The fence was up. The title was clear. No liens, no violations, no drama. My real estate attorney handed me the keys and smiled. "You handled that better than most people would have," she said. I thanked her and walked out to the driveway. The fence looked good. The neighborhood was quiet. Betty's rolling file cart was gone. A few weeks later, I saw her at the grocery store. She did not make eye contact. She pushed her cart past me without a word. I did not say anything either. There was nothing left to say. The board election happened 2 months later. 3 new members were elected. Betty did not run. The new board passed a policy requiring all enforcement decisions to go through the management company with mandatory documentation and appeal rights. They also banned rolling file carts at meetings, which made me laugh. Greg texted me after the election. "That fence of yours started something," he wrote. "People are finally pushing back." I replied, "It was just a fence." He sent back a laughing emoji. Sure it was. I sat on my patio that evening looking at the fence. It was solid. It was level. It was exactly what I had wanted. And it had cost Betty everything she thought she controlled. The moral of the story is simple. If someone tells you they have a committee for that, make sure you have a document for them. And if they try to send vendors to your property without permission, ask them for their legal authority. Most of the time, they do not have any. I hope you stay well.